Okay. All right. So thanks everybody for coming. I have a whole plan for tonight. Hopefully I won't keep you for more than about an hour, hopefully even less. But I know that your oral arguments are coming up. And for anybody that looked at the Calendly and there wasn't enough slots, first of all, I apologize. I was trying, there's 36 of you, so I wanted to make sure each of you have at least a 15-minute slot, and I anticipated to go over if you guys have any questions. So scheduling that was a bit difficult, but I was able to reschedule something that I had for that Monday evening, and I just added another 8 slots on Monday evening. So if that interests anyone, if you'd like to move it there instead of Sunday, or if you have not booked it yet and you still want to, that's available for you. But otherwise, I guess we could get started. So hold on one moment. 1 second. Oh, we have a question. Okay, if anybody needs to leave early or anything, that's fine. I'm not going to even take attendance. It's fine. All right, so we have, is that visible for you? It says oral advocacy workshop and it's green. It's orange. Is that a yeah? Can just someone say yes or no?
Yes.
Okay. Thank you. All right, cool. So today I'm just going to go over basics of oral advocacy so that you know what's going on when you do your oral arguments. Has anybody ever done anything like this, or is this the very first time that you guys are being presented with an oral argument? You can like raise your hand if you've ever done anything like this. Your little hand, their virtual hand. Yeah, it's okay. Oh, we have, wow. Oh, you know what? What am I saying? We just had our moot court competition. So if you guys did that, then yes, this isn't new to you. But if you didn't do that, and it's okay if you didn't, this is probably brand new. And I can tell you, before I came to law school, I did not even realize that there was a difference between mock trial and moot court, or in the same sense, in terms of litigation, trial and appeals court, which is really what you're dealing with here. So it's okay if you're starting from nothing, because that's essentially the entirety of law school. So that's fine. All right, so we're going to start with an introduction, and I'll give basics, and I have a procedural history slide so that we can make sure we're all on the same page with your case's procedural history. And then I'll go into how to do an oral argument, not only the actual words that you should say, but generally how it works in terms of a roadmap, like what the introduction sounds like and what the body sounds like and conclusion. And then also appellants are able and allowed to give something called a rebuttal. So I'll be able to go over that as well. And then I'll actually be doing a live oral argument. He's not here yet, but my partner for an interscholastic moot court competition is going to come on to the meeting with us, and then I'll do a live oral argument and he'll be our guest judge. So I'll only do it for about 5 minutes, and just to give you a feel for what it should look and sound like. And then I'll open it to questions, in which if do not feel like any question is a dumb question. Like I said, this is something that nobody ever really experienced before law school. So it's not like you're born knowing how to do an oral argument. All right, so introduction to oral advocacy. Anybody want to volunteer to give a procedural history of your case with Ms. Walker and the US government? It's okay if you don't, but it would certainly be more fun. I'll give you a second. Or you know what? Maybe even easier. Just what's the very first thing that happened in this timeline of procedural history? And I know that if you go to your brief that you just submitted, there should be a procedural history section. So it might be there for you if you just wanted to read it, but I have it prepared if nobody wants to do it. No? All right, that's fine. All right, so the very first thing that happened was the US government arrested Walker. I have it in timeline form here just so that we can get a picture. On January 30th, 2021, the US government arrested her. Then in March of 2021, also, the US government indicted her for 1 count of unlawful sports gambling. This should be review. You should know this information. I just pulled it from the appellate record that Greene provided to you. Then in May of 2021, Walker filed a motion to suppress evidence. And what she was motioning to suppress was the laptop found during the search of her garage. So she said that evidence should be suppressed. It should never get into the trial. And she filed a motion to that effect. Then in that same month, a couple of 20 days later or so, the US government filed a response to that motion saying, no, we do want that evidence in trial. And then a couple months later, in July, there was a hearing figuring out, what do we do? Do we let this evidence in or do we not? And then in November, the district court denied Walker's motion to suppress. So that means that the district court said at that time when they denied it, no, we are admitting the laptop that the police found during the search. Your motion to suppress is denied. Then in December, Walker appealed that denial of that motion to dismiss. So the reason why I wanted to go over this is because now we're at the appellate level, but we have not had a trial. There has been no trial yet. Maybe there would be in the future, but this is all about a motion to suppress and not about a trial. Usually when you hear about an appeal, it's the decision of a trial and then somebody's appealing that decision. But right now we're just appealing the motion to suppress. Any questions on that? That actually becomes really important when you're arguing your oral arguments. That might be one of the questions. No questions? Okay. All right, so then there are two main steps when you're talking about appellate advocacy. So the first thing you guys already did, it's your brief. So depending on if you're the appellant or the appellee, appellant is Walker, correct? That's right, right? Yeah, okay. So if you guys are representing Walker and you're the appellant, you wrote a brief and you submitted it to Greene, or in real world, it would be you submitting it to the court. And then the court reads it and reads all about why you think the motion to suppress, the motion to suppress should actually be granted, and that decision should be reversed. But if you are the government, you like the previous decision because the previous decision sided with you and said, yes, we are allowing that evidence to come in. And so you want to affirm the decision of the district court. So all of that was in your brief, and you talked about the cases that supported your argument one way or the other, any statutes that supported your argument, it's all in writing. But then after the brief, after you submit that, the next thing that happens is this oral argument stage. So now not only did you submit in writing the argument that you're making to the court, your oral arguments is you physically bring yourself to court, or Zoom land in this situation, but you physically bring yourself to court and you give the judges an opportunity to ask you questions about what was in your brief. And you, as succinctly as possible, articulate your arguments orally. But it's really the same argument that you made in your brief, but you're just actually arguing it orally. So, and really the big difference between that and the brief, aside from the actual writing versus the oral argument, is you get questions from the judge, and the judge likes to interrupt you while you're speaking, which is rude as anything, but that's the name of the game. And so I'll go into exactly how you should address that and what kind of answers you should give when the judge asks you something. But this is what it looks like when we're not in Zoom world. And you go to court, this guy arguing at this podium is giving an oral argument in front of the bench of judges. So a huge difference between appellate court and a district court is that the district court, you're trying to get people on your side. You're trying to get the jury to buy your argument. But here, there's no jury. You're trying to get judges to buy your argument, which is why generally when you're giving an oral argument at an appellate level, it's so much more academic and so much more, you need so much more legal authority than you do at the trial level when you're just trying to get 12 people, regular lay people, to side with you. You kind of dumb down the evidence at that point. But now you want to be very articulate. You want to give as many cases as you can, and you want to cite to everything that you say just in a way that you're actually saying it. So instead of saying in a brief, Miss Walker's subjective expectation of privacy is one that society would deem reasonable, and then you cite to Florida v. Riley, California v. Serralo afterwards in a parenthetical citation. Instead, you would say, according to this court in California v. Serralo and Florida v. Riley, this court should hold this because, and so you actually verbalize the citation rather than write it in a brief. But this is what it looks like. I found that on Google. I don't know which court this is, but it looks pretty nice. Looks very legal to me. All right, so then a couple of things about what kinds of questions you should be expecting Greene to ask you. And if you ever do any appellate advocacy, what to expect when a judge asks you. Essentially, when do they happen? It's the entire time you're talking. There's never a point that or a time that's off limits from questions. From the very first second that you start to the end of when you finish, it's fair game, and they can interrupt you. And sometimes, yeah, so it happens throughout your argument. What do they ask? What is Greene going to ask you, and what do the judges ask? Most of the time, if you have a good understanding of what the other side's argument is, that's usually the basis of the questions from the bench. So, for example, if you're arguing for Walker and you're the appellant and you're saying that her subjective expectation of privacy was one that society would deem reasonable, and therefore the motion to suppress should be granted and the lower decision should be reversed, that's your argument in a nutshell. But if you understand why the district court denied the motion to suppress, and you're able to counter the government's argument, like at the drop of a hat, you'll probably be fine in any oral argument. That's generally the basis of what the judge wants to know. Sometimes they ask it as straightforward as, how do you get around the other side's argument? Like sometimes it's as simple as that. And then you're like, well, and you have to not only understand what it is that the other side is arguing, but you have to be able to respond to it orally. So generally, if you're able to articulate a counter argument to the other side's argument, you should be good. Like you should be in a great place. However, another type of question that you might get from Greene, I think this one is a huge one that she might ask, is that you have to be able to distinguish other cases that weren't so great for your side. So if you're Walker and there was a case that was super similar in the facts, at least when you're looking at it from a glance, it seems like this case was the exact same situation that Walker dealt with, but that case denied the motion to suppress, the motion to suppress, and you're asking the court to reverse that. So how do you get around this other case? And at that point, you answer that and you say, well, that case, the court dealt with this. And here it's a factually distinguishable circumstance. And you give a distinguishing argument and why, even though that court was right, because obviously, especially if it's the Supreme Court, even though that court was right and might be binding on our decision at the circuit level, that is a different factual circumstance. And if you're able to do that, you should be able to get over any kind of question that they ask you about precedent. So the question might be, how do you distinguish this case from here? Or how does this other case impact your analysis? So in that way, I would try to know the cases that Greene has given you. Can anybody tell me how many she's given you in that list right before you wrote your brief?
15.
Okay, that's a lot. All right, I'm not going to diminish the fact that that's a lot. If you have time, I would say that make a list of those cases and a quick one sentence factual line about that case, and then also what they held, so that you know how to distinguish that case if it comes up. And if a case like was for the other side and wasn't so great for your side, be able to articulate why we shouldn't follow that same thing. Well, because the facts are different. Usually that's the best answer. It's just a different factual circumstance. And then another one is sometimes they go, what should we hold, counsel? Like, get to the point. Like, stop beating around the bush, just get to the point. You guys are arguing in front of a circuit court, right? It's not the Supreme Court. Yes, right. I see a head nod. Yeah, so you're not going to lay out a supreme law of the land like the Supreme Court would, but generally speaking, whatever the circuit court does hold, it will be persuasive on the circuit court, persuasive on the Supreme Court, and then binding on the district courts. So sometimes the judges just, or Greene might want to know, what is it that you want us to hold? So maybe be prepared to answer that depending on what side you're arguing for too. That's a good question she might ask. But I have a feeling she'll err on the side of the precedent and the counter arguments. That's my guess. All right, and best practices. All right, so when you're doing oral arguments, what you have to do is give deference to the judge. So instead of saying, Professor, don't say that. Say Your Honor. So Your Honor, if there's another person that Professor Greene brings in on the oral arguments, say Your Honors. Oh, my partner is here from moot court. Devin is coming in. So make sure that whenever you're responding to Professor Greene's argument, her question, or maybe someone else that she's brought in, Your Honors, No, that's not the case. Your Honor, yes, that is the case. So be as respectful as you can to the questions. Don't seem annoyed that they have interrupted you, even though they will, and even though it is annoying. Don't let your face show any type of annoyance. That's bad. That might lose you points. Also, answer the questions as directly as possible. So I've given an example. The question is, wouldn't you agree? Okay, so let's say this would be Walker. If you're arguing for Walker, this is an appellant question. Wouldn't you agree, counsel, that since Walker's garage had windows, her subjective expectation of privacy is not one that society would deem reasonable? Anybody want to take a stab? As Walker, how would you respond to that question? Counsel, wouldn't you agree that since Walker's garage had windows, her subjective expectation of privacy is not reasonable? Yeah, Olivia.
No, Your Honor, I would not agree because the windows on the garage were particularly small and the doors were shut fairly regularly. I don't know.
That's the answer. So good. That was the answer. So no, Your Honor. And I loved that you started the answer with no, or whatever you said, Your Honor, no, that's not the case. Because what often will happen is that your natural tendency will be to agree with Professor Greene. I mean, she's a wonderful person. She's agreeable. So like you'll be, well, yes, that might be true, but this, or yes, Your Honor, I agree, but this. Don't do that. That actually, I don't know if that might not lose you points, but it devalues your argument when you acknowledge that what the judge just said in terms of a counter argument is right. Like, don't give any oxygen to that point. Instead, say, no, Your Honor. The windows on Miss Walker's garage were located at the very top. They were 4 inches wide. That I don't know if it's true. That could be wrong factually, but they were super tiny. Therefore, an individual would not be able to view the contents of the garage if they were standing from the street. The only way that somebody could see the contents of that garage is if a drone flew above eye level. So therefore, the subjective expectation of privacy is reasonable and would be one that society would deem reasonable. And so you just basically verbalized a counter argument that you may have put in your brief if you were Walker. And the same way on the other side, it would just be the opposite question. Like, well, if you're the government, well, counsel, weren't the contents of the garage protected by a garage that was enclosed, and wasn't the doors closed? Weren't the garage windows super tiny? And then what would you say to that? Any takers for that? I don't have an answer for that. This just came into my head now. It's okay if you don't want to, but Olivia, yeah, go ahead.
Because this is my side. I would just say, no, Your Honor. If Miss Walker had an expectation of privacy, then those doors would have remained shut at all times, and she could have put a screen or a sheet over those windows and locked the garage.
Sure. Yeah. Yeah. The windows themselves were transparent. So yeah. And then I have a blank here for as the court held in. So I didn't read all of your 15 cases. I'm going to be completely transparent with that. But if there is a case that helps you articulate this argument, it's always good to throw that name of the case in there and say, well, in this case, it was a similar circumstance. There was a garage with windows, but because they were so small, the court didn't find that to be something that would bar her expectation of privacy from being reasonable. So then it's like you just used an argument that was articulated in another court and you threw it into your argument here. Like, you'll get 100 if you say that, I swear. So that's generally how you answer questions. Answer them as directly as possible. Don't say something that is not about the question. And this is a good point, because if you are talking about something else and it has nothing to do with, you're not even at this stage yet about the windows, you haven't even mentioned the garage door, she may interrupt your argument and ask you this specific question. Drop what you are doing and answer that question. And you can always go back to your argument afterwards, but the most important thing is to answer her questions. Also, after you answer her question, do not wait for her to be like, good point, go on. Don't stop and wait for her to nod her head or say okay or say good job. That's not going to happen. It's just going to be an awkward silence. So don't do that. Don't wait for the judge to say anything. They won't say anything. And then it just sounds like you don't have control over your argument. You want to have the control. So what usually, this is a good way to say this. If you want to tie it into your next argument, say this: that brings me to my next point, even if it doesn't. Even if it really is not related to your next point. If you say, thank you, Your Honor, and then you go into you answer the question, no, Your Honor, this is the case instead, and that brings me to my next point. And then you keep talking, the judge won't have an opportunity to stop you and ask you another question. So that's generally a great line. That brings me to my next point. It signals to the judge that you have the control over your argument. And even though they just interrupted you, you just brought it back to what you want to say. You have control. If anybody has any questions throughout this entire thing, just put your little virtual hand up. That's fine. And then another thing is it has to be conversational. So even though you may have an inclination to give a speech, that's fine. You should probably have something prepared before you go into the Zoom meeting, but it should sound like a conversation. It should sound more like you're talking to someone. And then that makes sense, right? Because the person is actually asking you questions. So you're answering the question and then you're moving on to your next point. It's almost like you're sitting at dinner and you're talking about Miss Walker's subjective expectation of privacy and whether that subjective expectation is reasonable. And it's like, you never talk about that over dinner, over drinks, but like, it's supposed to be a conversation. Try to be as articulate as possible. Try to think about what you're saying before you say it. And this is totally fine if you want to do this. Take a few seconds before you answer the question. Sometimes judges, and I bet Professor Greene would have respect for you if somebody asks you a question, if either her or her guest judge asks you a question and you go, well, Your Honor, no. And then you just took a few seconds to think about it. And I bet you that at just doing that and taking a couple seconds to answer the question, it might feel like a million years in your head, but it's not. She won't even bat an eye at that. Think about the answer before you say it and you will be more articulate. And also speak very slowly if you can. You will always think that you're speaking too fast, but you're not. You will always think you're speaking too slow, but you're not. You're always speaking too fast. Everybody does it. I do it too. And then try to keep it concise too. Say less. All right, the time constraints. You're going to have 8 minutes to do this argument. Except if you're the appellant and you want to reserve 1 minute for rebuttal, which is giving you the opportunity to respond to the respondent's argument. I'm sorry, the appellee's argument. They're one and the same, respondent, appellee. But if you go as the appellant, you'll go, then appellee goes. And then as the appellant, if you want to save a minute so that you can talk about what appellee just did wrong, save a minute for rebuttal. I'll go into that in just a moment and how to do that. But overall, generally, you're going to have 8 or 7 minutes, depending on whether you do this rebuttal. I happen to know that Professor Greene is going to use the Zoom chat feature to do this. I asked her about this ahead of time. So as you're arguing, what you want to do is, because we're doing this on Zoom, is to put your chat feature somewhere on the screen so that you can see it, because she's going to do this in the chat. 5 minutes left, 3 minutes left, 1 minute left, 30 seconds left, and then you'll see a 0. And then when you see the 0, we'll talk about what to do and how to jump to your conclusion. But generally, that's how it's going to work. She's not going to use any paper because that's just a little harder. So she's going to use the Zoom chat feature to show you how much time you have left. Any questions so far? No? Okay. All right. So how do you do an oral argument on Zoom? Before COVID, this was never even a question. But generally, the regular Zoom etiquette flows, like make sure you have a background that's not crazy. Wear something. You don't have to wear a suit, I don't think. Has she given any guidelines on what you need to wear to these oral arguments? No, I mean, I don't know. So I don't want to say something wrong. Like, it's okay if she just said nothing, but do you know if she said anything about it?
She said something nice, but it doesn't have to be like super like formal or anything like that.
Thank you. Okay, yeah, thank you, Gina. Okay, perfect. So just wear something that I wouldn't wear like a sweatshirt. Don't wear maybe pajamas, no robes. I'm sure that you guys have this down. Also, don't talk over the judge. And the reason why I say this is because it's a little bit more difficult to deal with this on Zoom than it is to deal with it in person. Because if you're talking in person and somebody interrupts you, there's never a delay. There's never a microphone issue, but just be aware that we're on Zoom. So just keep your ears peeled, to say for lack of a better word. Make sure that if you hear a sound coming from the judge, it might be a delay. Make sure that you stop talking and acknowledge that there's a question. Never talk over the judge. And if you see that happening, like check yourself. And yes, Megan, is there a question?
Yeah, I just had a quick question, but you can finish your train
No.
of thought before.
No, that's okay. I'm glad you raised your hand. I was just going to say, so if you see that there's a delay in either you or Professor Greene's microphone, generally take the onus and you talk slower, like takes a couple of seconds in between your sentences if you see that there's a delay, to try to prevent that. Hopefully that doesn't happen to any of you, but just be aware that Zoom, sometimes those issues are unavoidable. But yes, Megan, what is your question?
Are we supposed to be sitting or standing when we're doing our argument?
Good question. I always sat. I've never done a moot court or an oral argument standing. I don't like it. For mock trial, I do mock trial as well. I always stand for that. It's different because for moot court, it's less about commanding the room, especially on Zoom, and it's more about substance. But for like a trial level, you really want to be very effective in your tone, in your, like, maybe use your hands as a little sparingly, and really show that you have control over the courtroom, not just what you're saying. But you can sit, that's fine. I would say whatever you feel most comfortable with. I like to sit because I never can speak without using my hands. I don't know what it is, so I sit on them. Try not to use your hands in a moot court. I'm sorry, I keep saying moot court because that's really what this is. Don't use your hands in an oral argument. Just don't do it. Try to be as objective and calm as possible. There's no showiness. There's no theatrics of this. Good question. Okay, eye contact. And I have a slide specifically for this because I'm going to show you how to do this on Zoom. So for eye contact on Zoom, you may have your notes at the bottom of the screen, or if you have them printed out, you may be doing this. This is my recommendation. I do not proclaim to be an expert in oral arguments or moot court by any means. However, this has worked for me, and people have told me that, oh, I thought you weren't reading, or you did a great job with eye contact, and this is what I did. You bring your notes up and you bring the Zoom down. This is what it looks like. I took a screenshot at our last moot court interscholastic meeting. Devin, are you here somewhere? I saw you come in for a second, but I don't know if you're here.
Yeah, I'm here.
Oh, Devin, hello. Okay, I'll introduce him in just a second. Oh, you're wearing the same jacket as you were a couple nights ago in this picture. But yeah, so I took a screenshot because this is what I do when I do any kind of oral argument or moot court or argument. You bring your notes up to the top. You get rid of any toolbar so that it really gives you the best chance at having your words as close to the camera as possible, and then having your Zoom down there so that you're really not looking at that. But if somebody starts talking and there's you see how Devin in this photo has a green outline over his box, that means he was talking. So whenever someone's talking on Zoom, that happens. So just, it's still there for you at the corner of your eye. If you start to see somebody do that, that means they're trying to talk. But you have your notes up at the top so that, and also you can distance yourself a little bit from the camera. If you wear glasses, which is obviously, I wear glasses, if you have contacts or any other option, wear those. And I know that sounds crazy, but the reason why I say that is because when you wear glasses, the screen reflects off of your glasses, and then you can see your notes from your glasses. So I wear the contacts when I'm doing any kind of thing like this. But if you don't, I mean, that's certainly not something you need to worry about. Trust me. But if it's generally, it makes the person think that you're really looking at them on Zoom. So this is just whatever you use. You don't have to do this. This is my own personal recommendation. Any questions on that? All right, so now let's get into the actual structure of the argument. And Devin is here to be our guest judge because I'll do like a 5-minute portion of our current competition argument, and he'll throw questions at me, and I don't know what he's asking me. To keep this as real as possible, we're just going to see what he asks. I'll answer, and you'll get a feel for how this works. But before you actually get into the meat of your argument, this is what you do. This is what it looks like. So I'm assuming Professor Greene will be the Chief Justice, which means the person that has, I guess, most control over the bench, or it's really like the person that's most esteemed on the bench. maybe ask that question before you actually argue. Professor Greene, are you the Chief Justice or is your guest judge the Chief Justice? She'll be like, oh, like, okay, like, you know what you're talking about. And so what that question, what that does is it signals whether you should say Madam Chief Justice or Mr. Chief Justice. It's the first word that you say. The first line that you say is Madam or Mr. Chief Justice, and may it please the court. If you don't say that, you can't say anything. They'll interrupt you and they'll kick you out of court, or they'll kick you out of Zoom. I doubt Professor Greene will do that, but I'm trying to make this as real as possible for if you ever do this in real life. So, Madam Chief Justice, and may it please the court. My name is Nicole Case, and I represent the appellant, Ms. Walker, in today's matter. Today, I will argue that Ms. Walker had a subjective expectation of privacy, and that expectation was one that society deems reasonable. That's your argument. That's, you know what, that might not be your argument. I just said that off the fly. So if you don't want to use that as your argument, that's fine. But generally what I just did was I took the fact pattern and I articulated overall what would be the thing that's dispositive in this case. And so it's this one-liner that today I will argue this. And so that certainly might not be the argument, but that's generally what you do. If you are the appellant, and I promise I'll get to the rebuttal in like 2 slides, but if you are the appellant and you want to reserve that rebuttal time, that 1 minute rebuttal, you say at this time, appellant requests to reserve 1 minute for rebuttal. And then you go into your roadmap, which you say, Your Honors, the decision of the district court holding that, or deny, in this case, it would be denying Ms. Walker's motion to suppress, should be affirmed if you are the government, or reversed if you're Walker, for 2 reasons. And then we'll go into what happens next and how you do the first and second argument. But that's how this is. Also, I have posted on like my TA site a Word document with this stuff in it if you want to use it. This is always what I use whenever we do any kind of moot court or oral argument. I always go to this Word document and it's blank for you. So it's there under oral arguments. And I also posted the PowerPoint for today if you guys want that in the future. Okay, any questions on that? This is before you even really argued anything. This is just the introduction. Okay. All right, next we have the body of the argument. Now you have 2 subpoints that speak to the overall issue in the case. This is what it looks like. So you go, as to my first point, and the first thing that you want to do is say a conclusion. So I have here cray, and the reason for that instead of a creac is because if you start with the explanation section before you get to your application, like you do in a brief, you'll get questions from Professor Greene or the judge before you even talk about your case. And in order to really maintain control over your argument, generally speaking, you want to give the application section before you give your explanation section, just so that there's no opportunity for you to get a question about this case before you have had the opportunity to articulate your own argument about this present case. It keeps the structure more to your argument, and it will lessen the chance that you're diverted away from what you have written. So Jen, this is again personal recommendation to do a cray formula instead of a creac, and your conclusion is your point. So whatever it is that you said here, first, Ms. Walker had a subjective expectation of privacy, and you don't need to use these arguments. I'm just saying, first, Ms. Walker this, and that's your first point. Repeat it here. As to my first point, that Ms. Walker had a subjective expectation of privacy, move on to the structure of your argument. Then, so after you give your point as the conclusion, you want to give a standard, which is the rule. So give a case that defines what it means to have a subjective expectation of privacy at all. And then we're going to use that standard, apply it to this case, give an explanation section very briefly, maybe throw in 2 other cases that dealt with similar issues and found in favor of your client. And then your conclusion, I say that a conclusion weirdly though, because I don't think you should restate the conclusion. It'll just waste time. And at that point, you've already articulated your point up where when you said, as to my first point. So that's a decision you can make if you want to restate the conclusion before you move on to the second point. But in my opinion, and Devin, you can disagree if you think, because some of this stuff is stylistic preference. But in my opinion, if you move from a conclusion from your first point into your second point, it sounds a little bit more disjointed. It's more flowy if you move from the explanation section of your first argument, and that brings me to my next point, instead of giving a conclusion before you move to your second point. And that's your discretion. You're the arbiter of whatever goes into this argument. But generally speaking, you could do any of that stuff. And again, this is all on the TA site. Any questions about that? And then you do the same thing for the second point. As to my second point, restate the conclusion or the point, you give a rule, application, explanation. Questions about that? Okay. Now you have your conclusion section. So this is what it looks like on the right, but I have on the left here a thing that might happen to you is that you are cut off from time before you actually are at your conclusion, which might happen. It probably will happen, especially if you have only eight minutes. So if that happens and you see the 0 come up in your Zoom chat feature, you say, Your Honor, I see my time has concluded. May I briefly conclude? Or I see my time has run, so that you're not using conclude twice. Your Honor, I see my time has run. May I briefly conclude? She's not going to say no. Instead, it alerted her. It sounds nice, especially at this level, like at an oral arguments for Professor Greene. So if you see that 0, Your Honor, I see my time has run. May I briefly conclude? And then what you would say is the short conclusion here. I have a long conclusion section and a short conclusion section, and I'll explain why. But you would jump to your short conclusion if you have a 0 in your Zoom chat box and say, for these reasons, the court should affirm or reverse the decision of the circuit court. Uphold is the same word as affirm, but Devin and I were told by our coaches to use the word affirm instead. So it looks like I just didn't fix uphold to affirm. So use the word affirm. It's generally more legal than uphold. So for these reasons, this court should affirm the decision of the district court. Boom. That's it. That's your conclusion. It's a one-line thing. What do I have here in green? This conclusion. Yeah. So you have to say that. Don't finish your argument until you do that. If you don't do that, and that's not the last thing that you do, the court is maybe wondering whether you want them to affirm or reverse. And that's literally the be all end all of what you're trying to get the court to do, whether to affirm or reverse. That's the disposition that you want them to do. So make sure that you do that. Do not finish your argument without saying that. Perfect. However, that is one situation that might happen, that you see a 0 come up. Another situation is that you see the 0 come up and then you get a question. So if Professor Greene throws a question at you and like while she's talking, you see the 0, that's when you do this thing. I see my time is concluded. May I answer your question and briefly conclude? And she's not going to say no to that either. So that signals to her you recognize that you're out of time, but you don't want to finish without answering the honorable's question. So you say, Your Honor, I see my time has run. May I answer your question and briefly conclude? And she'll say yes. And then you answer her question back to the making sure you're direct about it. No, Your Honor. Yes, Your Honor. Then why? And then you say, and for these reasons, this court should affirm the decision of the district court. The third option that will happen is that the 0 doesn't show up because you finished your argument before you actually got to the end of the time. That's the third and really the only 3 situations that can happen. So if number 3 happens and you don't see that 0 and you're like, I'm done. What else do I say? That's why you have a long conclusion prepared too. You probably won't get to the long conclusion. It's more likely that either option 1 or option 2 will happen and the 0 comes up before you're finished. But if the 0 doesn't come, make sure you have like a paragraph overall giving a conclusion of why you want the court to either affirm or reverse the decision of the district court. And then it'll save you if you have more time and less words to say, then you give the long conclusion, and they like that. They like when you give a long conclusion. It's just most often it doesn't happen. So that's how you handle the conclusion portion of that. Any questions on that? All right, we're rocking. Rebuttal. This is only for appellants. So I'm not going to say appellees like close your ears, but this is only, I mean that in the sense that only appellants can request rebuttal because, appellee is a rebuttal. If you really think about it, appellant gets up first, articulates their argument, appellee comes up and responds to appellant. But then that's not fair. Appellee has the last word. Appellant, it brought the action. Appellant is the one who is appealing the decision of the lower court anyway. So that's why they have an opportunity to reserve 1 minute out of their 8 minutes, or whatever time it is that you are in real life. She's giving you 8. So you take 1 minute out of your 8 minutes and you save it. And then after appellee has given their argument, you have another minute to now address what appellee said. And it's generally an effective thing if you do it right. So I'm going to tell you what to do. It's not required yet. I already checked with Professor Greene. You're not losing points if you don't do a rebuttal. But I think you should. It's up to you. Sometimes you can reserve the 1 minute and then not even use it if you really feel like there's nothing that you would add to the argument. But it's up to you whether you want to do it. You're not going to lose points either way. This is what it looks like. You get up and you say, Your Honors, just one brief point addressing appellee's argument. Appellee just stated that the standard for whether the Fourth Amendment should apply to the contents of Miss Walker's garage is that Miss Walker needed to have a subjective expectation of privacy. However, in Katz v. United States, the standard is actually not only that Miss Walker needs a subjective expectation of privacy, but also that that expectation needs to be objectively reasonable. And here, even though Walker may have had a subjective expectation, it was not one that society would deem reasonable, and therefore the decision of the district court should be reversed. Thank you. And then you sit. That so what I just did there was I hope so make sure if you're the appellee that you don't give the standard as only subjective, because we know that it's subjective and objective. It's two-pronged test. But if as appellant you hear a standard that's not articulated correctly, bring it out. I mean, you don't have to be rude about it. In fact, I wouldn't be rude about it, but address something that maybe appellee got wrong in terms of a standard. Maybe they cited to a case that they got the facts wrong. Maybe they cited to a case that really is so different than this case that we can't possibly look at that case for any type of authority. So sometimes a factual distinguishing can happen in a rebuttal, and sometimes that's an effective use. It really depends, and it's not even something you can really prepare because it's specifically based on what appellee argued instead of appellant. So again, not required for you to do, but I have to believe that it'll get you brownie points if you do. That's just my opinion. Any questions on a rebuttal? And it only is 1 minute, so don't go up there with like 6 arguments. Like literally it should take you maybe 30 seconds. All right, we're at the stage now that Devin, I have our esteemed guest judge here. Devin is on the Hofstra Law Moot Court Board. He is an interscholastic competitor. I am on his team, so we are partners in this. We are both competing in Brooklyn Law's, what is it called, Devin? The official name?
Jerome Prince Memorial Invitation.
Yes.
Invitational.
Yeah, it's an evidence competition. So when you take evidence, or yeah, you have to, in the coming years, you'll learn that there are certain federal rules of evidence. And so we are arguing that certain things fall within the meaning of the rules, some things don't. And so it's been fun, right?
Yeah.
Well, I have him here because we are partners, like I said. And so I thought about whether I should do a live oral argument with your fact pattern. And then I was like, that's probably not a good idea because first of all, it would be unfair. I think that would be a little too substantive in terms of help, and it might cross the line what I'm allowed to do. So instead, I am going to give a live oral argument for our competition. So don't look to this for any substance. This is strictly so that you understand how it should sound, how it should look, especially on Zoom, that kind of thing. So, but before we begin, any questions about anything that's happened so far? All right, great. After we do this, it's just going to be an open Q&A. So this is the last like substantive thing that will happen. And Devin, I'm only going to do for like 5 minutes or so. Is that cool?
Yep, works for me.
All
Can
right.
you hear me good? You can hear me good?
Yeah, I can. I'm going to stop
Okay,
sharing. Hold on 1 second.
Awesome. Enlarge the screen. Awesome. Ready whenever you are, Nicole.
All right. Okay. All right. So you see what I'm about to do here. I'm bringing down Oh, maybe I should have shared my screen. Oh, wait, can you still see my screen? Or no? Okay. Okay, this is great. I'm gonna show you how to do this when you're actually setting up your screen. Sorry. All right, you see, this is my argument. I'm bringing it up to the top. I'm bringing you guys down. Yeah, that's it.
So
And so, yeah. Okay, yeah, so yeah, that's all. So it's up here. I'm bringing up my toolbar so that so now I'm gonna ask you a question, you guys. Does it look like I'm reading anything? A simplified mock appellant argument, issue 2 and 3 respondent. Does it look like I'm reading anything? I can't see you guys, so I don't know. Oh, I just saw a shake of head, so I hope that answers no. So so generally take like a foot between the screen and like distance yourself just a little bit so that it really doesn't look like you're reading. And I will actually, I don't think you should read. I'm not saying that you should read and this is like a way to get around getting caught. I'm just saying that I think that you should have notes in front of you, especially at this level. And if you want to do bullet points rather than actual like written out arguments, that's fine. But generally, if you want to use notes, this is a way to do it, and it doesn't it's not rude in the sense that you're like looking like this. Like I've seen someone do this before. Like that's just that's what I would not do. All right, so I'm going to stop sharing so that you can't see that, but okay, I'm bringing you down. Hold on, sorry. Okay, all right, Devin. So Devin is a Mr. So it's a Mr. Chief Justice instead of Madam Chief Justice. So make sure that you ask here. I'll do this for a simulation. Your Honor, who is the Chief Justice?
I will be the Chief Justice.
Thank you. Okay, Mr. Chief Justice, and may it please the court. My name is Nicole Case, and I represent the respondent, the United States, in this matter. Your Honors, the ruling of the 14th Circuit should be affirmed for the following 2 reasons. First, Dr. Clouseau's theory on the reliability of eyewitness identification is inadmissible under Federal Rule of Evidence 702. Second, absent a specified order of sequestration, Rule 615 of the Federal Rules of Evidence only forbid witnesses from hearing other witness testimony during courtroom proceedings. As to my first point, that expert testimony on the reliability of eyewitness identification is inadmissible. Rule 702 provides the standards for when a witness who is qualified as an expert may testify in the form of an opinion. First, the witness needs to be qualified as an expert. Second, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand or determine a fact and issue. Third, the testimony is based on sufficient facts and data. And fourth, the testimony is the product of reliable principles and methods. Taking these elements in turn, even if we accept that Dr. Clouseau meets the first element and is an expert within the rules of federal evidence, Dr. Clouseau's theory does not meet the rest of the 702 elements. As for the second element, that the expert's knowledge will help the trier of fact determine a fact and issue, that is, to give the jury information that lay people typically lack. Here, Dr. Clouseau's theory suggests that in the presence of certain factors, such as stress and the presence of weapons, affect the reliability of eyewitness identification, and that cross-racial identifications are suspect. But despite petitioner's contention, this information is indeed knowledge that lay people typically have. It is up for the jury.
So I don't buy it that the average layperson knows that cross-racial identifications are inherently unreliable. Did you know that before you took on this case? Did you actually know that?
No, Your Honor, I did not know that information.
Then how would the average layperson know it?
Because it is up for the jury to decide whether an eyewitness identification is reliable and consider all of the circumstances that might affect the reliability. So it is up to the trier of fact to assess all of the circumstances in their totality, including the presence of weapons, the presence of stress, or if the identification is cross-racial, and determine whether that identification is
Counsel. The average layperson would not know that has an effect on perception and memory. Isn't Dr. Jack Clouseau merely just coming in, offering a specific opinion on the issue, and is essentially, it sounds like it's assisting the trier of fact to me.
No, Your Honor, it's actually deciding the ultimate issue that is for the trier of fact to decide. It is not assisting the trier of fact. And in fact, if we were to assess this—
But counsel, Federal Rule of Evidence 704 allows one to testify on the ultimate issue outside one testifying on the criminal defendant's mental state and an element of the crime. Could you please elaborate how they're testifying on the ultimate issue and how it's not allowed?
Sure. So Federal Rule of Evidence 702 states that an opinion is not objectionable just because it embraces the ultimate issue. But Your Honor, this opinion is not objectionable just and solely because it answers the ultimate issue in the case. But also it doesn't meet the rest of the elements set forth in Rule 702. Even if we were to remove the portion of Dr. Clouseau's theory that does answer the ultimate question, as the court did in United States v. Keim, Dr. Clouseau's theory still does not meet the rest of the 702 elements. And that brings me to the third and the fourth element, that the testimony is based on sufficient facts and data and is the product of reliable principles and methods. And here at the district court level, the district court was unable to determine whether Dr. Clouseau's theory was accepted by his peers in the scientific—
But counsel, he's testified over 100 times. He's been published numerous times. He has experience in the field. What's the test? How is this? Explain.
So the test isn't that he's qualified in the field. That's only the first prong of Rule 702 of the Federal Rule of Evidence.
I'm not going to qualifications. I'm going into the principles and methods. His principles and methods in his field, doesn't that pertain to peer-reviewed research and publication?
It does, Your Honor. And this court in Daubert analyzed that portion of the 702 rules and said that a testimony is the product of reliable principles and methods when that theory is scientifically valid and whether it can be properly applied to the issue in the case. And the issue here is that Dr. Clouseau's theory is not scientifically valid. The Daubert court gave us—
Counsel, we know it's not scientific. We're going to assume that petitioner argued before. They argued to specialized knowledge. In what context would this be scientific?
So even if we were to accept the fact that this testimony is not scientific, although Dr. Clouseau in his expert report did indicate that he intends to testify to certain psychological factors, which is a subsection of science, but even if we were to accept that this is not science, the court has the discretion of whether to use the Daubert factors, and they did so at the district level, and that is why they found—
But isn't there a more lenient standard in Kumo Tire Co? I feel like that would have been the more appropriate standard for the trial court to apply rather than use Daubert.
So to answer that question, Your Honor, the standard of review is essential. So at the district court level, the standard of review is abuse of discretion when they're dealing with evidentiary concerns. So when the district court analyzed the Daubert factors with respect to Dr. Clouseau's theory, they did so within their discretion, and it was not an abuse of their discretion to do so. So this court should not reverse the decision of this.
But counsel, I need a policy answer. There's been a growing acceptance of eyewitness identification experts being able to come in to testify regarding the inherent unreliability of witness identification. Doesn't this go to the pertinent issue of identity, and shouldn't we be accepting this type of testimony to come in? Because it will help the defendant. The defendant might go to jail. He might go to prison.
No, Your Honor, we should not be accepting this evidence in the form of testimony from an eyewitness, from an expert, rather. And the answer can be assessed through the Rule 403 balancing test. So the probative value of this theory is substantially outweighed by the risk of juror confusion. And a few circuits have assessed this issue and said that the exclusion of expert testimony under this Rule 403 is right, because an expert who is answering the ultimate question risks confusing the jury, and an expert's aura of specialized reliability and trustworthiness can be fatally suggestive to the average juror who may replace her own opinion with that of the expert. And for these reasons, the court should affirm the decision of the circuit court. Thank you.
Great job, Nicole.
I don't know what even, so essentially that's what it, I mean, I'm not proclaiming to be an expert. Neither one of us are. We're just doing an interscholastic competition. So this type of issue we've been dealing with for quite a while.
I'm arguing the other side, so that's why I was hammering her with questions, and she would hammer me with questions.
Yeah, I mean, we haven't done that yet, but Devin, don't worry, I got you. But yeah, so that's essentially what it sounds like. And yeah, so taking all of that information, and if you are on the TA website and you see the Word document and the structure, does anybody have any questions about maybe how I answered something? If you disagree with how I answered something, I know the substance is not something that you're familiar with, and that was really just for structure and to see how it should sound. But any questions or comments or anything like that? Devin, you have any words of wisdom? Devin is a TA for Professor White, which is another legal writing professor at what is that right? Oh no, that's not right, Devin. Who are you a TA for? Did he leave? Did that guy leave? Is he gone? Okay. All right, that's fine. I'll talk to him later. I think he's a TA for Professor Campagna. My apologies. But yeah, so if there are no questions, that's all I have for you. I've recorded the session, so I'll post it on our site. But I feel confident that you guys will be fine. And I know Professor Greene is grading these a little bit more leniently than certainly the Supreme Court would. So don't feel like you're about to go into someone that's going to be super heavy in terms of questions. And I think the way that Devin asks questions will be harder than what Professor Greene will for you. So I'm glad that was the illustration, because it's always better to prep with that in mind and prep with it to be harder. And each of you, if you guys want, I think this is actually required from Professor Greene. I'm not sure. I certainly am not requiring it, but I think Professor Greene is requiring it, that you guys sign up for one of the practice sessions. And what I'll do for that is that you guys should have your argument, have it prepared, because the best use of that time will be for you to do what I just did and for me to do what Devin just did. And I'll ask you questions the way that I think Professor Greene will. And we'll do the Zoom chat feature for the timing and everything to really give you a feel. So don't, that is not graded. I am not sharing the sessions in terms of like notes, or they're not recorded. Professor Greene is not hearing about how those sessions went. Don't be stressed about that at all. It's strictly for practice. But any questions at all? No question is dumb, I swear to God. All right. Going once, going twice. All right, that's all. Well, thank you guys so much for coming. Oh, wait. We have a question from the chat. Does each appellant get a chance to rebut for 1 minute, or is it just one of the two? Good question. I will find, so in real life, it's just one. But this is a teaching exercise. So if you are appellant and you want to reserve that 1 minute and then rebut appellant's issue, because I know you guys are dealing with different issues, right? Is that the case? Okay, yeah. So you may be dealing with one issue, but then the other person is dealing with another issue. Can someone tell me the issues, like what they are? I know I just said I was going to let you go.
It's a reasonable expectation of privacy, and then apparent authority and negation of consent.
Okay. Okay. So yeah, if you're dealing with the reasonable expectation of privacy, you're not talking about the third party consent, and vice versa. If you're talking about the second issue, you're not even touching the first. So what will happen is that appellant 1 will go and do issue 1. Appellee will go next and do issue 1, appellee side, and then appellant can, if they already requested the 1 minute, this is key. If you don't request it, then you can't do it, because Professor Greene will time you with 8 minutes. So you have to request it if you want to do it. You could request it and then not do it, but you can't do it if you don't request it. Does that make sense? You have to do it if you're even considering taking the time. So I'll find out that answer. My guess is that if you want to do it as appellant, you can, regardless of if your partner did. But you're not really, not really a partner, because you're not really working together, right? And you have no interaction with each other. It's strictly the interaction between you and the judge. So I'll find out that specific answer and let you know. Good question. Any other questions? No problem, Dorothy. All right, well, have a great night. Thank you so much. And I'll see you all individually during your practice sessions. So we'll get to know each other. We'll have some fun. Again, it's very stress-free. It's going to be Zoom because the oral arguments for her are Zoom. If she was doing it in person, we would do it in person. I just want you to get a feel for how to do it on Zoom. All right. For real this time. Have a great night. I'll see you guys soon. Thank you so much.
Thank you.
Thanks, Nicole.
Of course. Bye-bye, guys.